This is Las Vegas Real Estate Now with local real estate expert Harvey Blankfeld.
Where we want to educate you about our market, empower you to make wise decisions, and help you engage with our expert contributors. First, I want to talk on holding title. Now, this is a topic that has to come up every time we're transferring property. And my clients invariably ask me, Harvey, how should I hold title? And I really can't answer that question for them. Everybody's different.
Yeah,
So
everybody is different.
let's talk about the varieties of ways you can hold title.
So we have there are in the state of Nevada a variety of different ways that you can hold title. I'm going to talk kind of about the common ways that we see. First one is tenants in common. Tenants in common is basically described as ownership divided by a percentage. Is the best way to explain that. So
You would do that if you had like a roommate or a partner in a deal, kind of a thing.
Exactly. And even husband and wife, maybe where they've been previously married and have children with other spouses in the past, and they want to leave part of their property to their children.
Oh, good. That's
from a previous marriage. So that's where that could be used. The best way to grasp the concept of tenants in common is that it is equally divided up based on the agreement that you have with the people involved, and that share of ownership when an individual passes away will have to go through probate.
The other one is
Joint tenants.
Joint tenants.
So joint tenants works as, I call it, the last man standing.
Okay.
You can have
or lady, for that matter.
Or lady, that's right.
Make sure
or
we're
lady.
clear on that.
It can be. It needs two or more people, and as individuals pass away, the ownership is then divided among the remaining living people.
Right.
And it continually goes down the chain until the last man standing is the full 100% owner of the property.
And typically this is for a married couple. So if one of them passes, the other retains ownership without going through probate.
We don't really use. I mean, we won't usually say typically, but yes, typically it is.
Yeah,
we use it more as a estate planning type.
Sure. My understanding of it is this: is if you're married and you have this type of title where you're sharing it that way, one passes, the other gets it. But if the second passes, then it's subject to probate.
Correct, because
because
based on the rules of joint tenants, you have to have two or more individuals to stay as joint tenants on title.
The way that a couple can protect that asset from having to go to probate is I've always been advised by attorneys is to put it into a trust.
Correct, and that's another form of way of holding title would be into a living trust, designated with the trustees as well as the successor trustees. The trust acts as a separate entity basically from the individuals and will help with estate planning and the probate process, because there really won't be a probate process as long as the property has been deeded into the trust and is vested in the trust name.
We get to this other thing, this deed upon death. So what is deed upon death? How does that work?
So deed upon death is a deed that is recorded with the Clark County Recorder's Office. It basically takes the owners, say the parents own the property and they have a few children, and it's a deed where they remain the owners, the parents do, but they list their children as the beneficiaries. When they were both to pass away, the property would automatically transfer to the children. It does have the potential to avoid probate.
Okay.
So you can actually avoid probate. The ownership can come to the children. But it also comes with a little asterisk next to it, and that is the 18-month window to where creditors of the parents or the original owner have this 18-month window where they can attach bills or liens or whatever against this against the property.
Okay.
The people receiving the home on the deed upon death have very specific things they have to do. Notices and legal papers that they have to file in order to clear the 18-month period. And when I'm talking about the 18-month period, it doesn't mean that they're not the owner for 18 months. It means they're not going to be able to sell it.
This has been Las Vegas Real Estate Now. Thanks for listening, and remember to tune in every Saturday at 11 a.m. on 101.5 FM, 720 AM KDWN.